Yes, ma'am.
Blackstone versus Cashman.
Mr. Deptula.
Good morning, members of the Court. George Deptula representing James Cashman. This case is on further appellate review concerning whether an actual malice and corporate privilege instruction should have been given to the jury in a situation where Mr. Cashman was alleged to have intentionally interfered with Mr. Blackstone's existing employment contract and prospective employment. And at the time, the corporation involved, J.M. Cashman, Inc., was in a wind-down. And Mr. Cashman remained as a director and 50% owner of the corporation. I wanted to address the two rationales that were provided, first by the trial judge and second by the appeals court, on why that instruction was not given. And the trial judge felt that because the corporation was in a wind down and a lot of authority had been delegated to an independent manager who was brought in, that the actual malice standard would not apply to Mr. Cashman, who no longer had day-to-day supervision. I think the appeals court partially rejected that argument, but I think that argument is fairly clearly an error because particularly during a wind down, Mr. Cashman still, as any other ultimate corporate supervisor or owner, had the right to influence decisions, to try to affect decisions, to take any form of action, including enlisting his brother to fire Mr. Ferrari
But
or
Mr.
Mr. Blackstone.
Deptula, how can threats to kill be protected by management prerogatives?
I'm sorry?
How can threats to kill be protected by management prerogatives?
I think, there are two cases where there have been at least, I don't know how to, hyperbolic threats to kill. Mr. Cashman here was in Nantucket. He had spoken to Mr. Blackstone that morning, who had not delivered certain checks to him that
I
were
remember
required.
the record. I'm not certain.
Yeah.
And you know it better than I. No one was certain where he was that day. Nobody really knew that he was in Nantucket.
Well, I think he said he was in Nantucket.
I take it that...
To Mr. Ferrari.
I take it that in part the answer is that's a factual question that the jury has to decide. I mean, I take it that's your answer. The jury should have been charged.
They certainly should have been charged, in my opinion, on actual malice.
And then if the jury had come back and said this wasn't actual malice,
Yeah.
maybe the other side would have had it would have been a JNOV and...
Right. Justice Cowan, I think the appeals court sort of took the position which you just mentioned, but when they said that there was some, they said this case was not about Cashman seeking Blackstone's discharge, complaining about Blackstone's job performance or his alleged bias or taking other adverse employment action against him. Those would be potentially privileged statements and actions. The basis for the tortious interference claim here, however, was Mr. Cashman's threats of violence, which were words spoken over the phone. I mean, there's a difference between standing in front of someone, but...
Is actual malice incorporated into improper motive or means?
It was not by the trial judge in this case. I think in the employment context, every case that decided by this court has said in the employment context after United Truck Leasing versus Geltman, when the improper means and improper purpose test was established, it was still determined that for employment context, you had a corporate privilege and actual malice was required.
Okay,
Right.
so
There's been no...
So you get
The
past...
purpose of that privilege is to communicate adverse information about employees. That's what it's there for. And to the extent that this phone conversation was simply communicating adverse information, that was Cashman's opinion of Blackstone, it would have been fine. But the mechanism for interfering with the contract wasn't the adverse information. it was this threats to kill or threats of bodily harm under circumstances where the defendant knew or should have known they would be communicated to the plaintiff, and to intimidate him into leaving. And there's, I think this is what Justice Scalia, there is no privilege associated with intimidation. That's not information. That's not the sharing of information about an employee or the candid exchange of views. That's direct intimidation of the employee. How can we have a privilege for that?
Well, I think you're taking out, 30 seconds of blustering an outburst in a conversation where he was communicating information about the employee. He clearly called Mr. Ferrari up. I just spoke to this guy. He wanted me to indemnify him before he gave my check. He said he was withholding them. And what do I have to do? Go out and kill him, hit him with my baseball bat was essentially the communication. So it was not, I think the problem with the appeals court's decision is that they parsed off this momentary outburst that he had in the conversation, but clearly everything was related to Blackstone's job performance. And therefore, if you act in an inappropriate manner, but you don't necessarily lose the privilege. It's up to the jury to determine at least whether or not you had the level of spiteful, malignant purpose unrelated to a corporate interest that they have to find, not just to find whether there's some improper means by way of contemporary mores. So we didn't get the instruction that's been required in multiple decisions. I think the biggest problem is it's very easy at the trial or anywhere to say, oh, he threatened to kill him. I mean, it's very clear that he sputtered out some words that were misinterpreted for about 4 hours that way until he was contacted and he called up Mr. Ferrari and apologized later that afternoon.
Could you clarify what those words were?
I think
didn't it have something to do with either shoot him or hit him with a baseball bat?
That's correct. That's correct.
What do I have to do?
Well, Mr. Cashman, at the time of trial or at his deposition, didn't remember his exact words. He did say he used one of those two things. Mr. Ferrari testified and was refreshed by written notes he took and wrote to an attorney he called in to find out what to do about the situation, and said that he said, I'm going to hit him over the head with a baseball bat or shoot him between the eyes. I mean, he's committed this conduct, and it's been going on for some time, and
followed up with him and said, to sort of go, you don't really mean that, do you? Or you really mean that? Oh, yes, I really mean it. Obviously, Ferrari was quite alarmed by what he heard.
But that's true. But you have facts where Ferrari was quite alarmed, and again, it was clearly a comment made related to Blackstone's job performance, Ferrari was quite alarmed, and he went in and he spoke to Jay Cashman and said, oh, that's not going to happen. Don't worry about that. My brother wouldn't do that. He spoke to the lawyer, who then spoke to Jamie Cashman's lawyer, who said, no, I don't think that's the case, but I'll have him call you. Called Jamie and said, there was some attorney-client communication. Jamie called Ferrari back that afternoon before Blackstone knew about the event and said, I apologized and retracted kind of the intent of the comments. I mean, he was in a situation where once he apologized, it's a double-edged sword because it's kind of an admission that he had done something wrong. I think what he had done is just blown his head for a moment because he was frustrated over the situation but had no intent to kill Mr. Blackstone. And he made that very clear that afternoon. And I think when we don't have the jury instruction that's been required, you're parsing out part of this conversation, applying a contemporary mores standard to it when it clearly related to job performance. And we have two cases, the Signetti case and the Clement versus Revlin contracting, both of which were almost the identical thing. I'm going to kill you. In Clement.
Mr. Turner, let me ask you this. The appeals court sort of doesn't really come right out and say that the reason for the judge's failure to instruct is correct. It simply goes on to a harmless analysis. It sort of skips over it and says, in any event, even if the instruction should have been given, it was harmless. Do we view the evidence at that point in the light most favorable to either party, either to your client, if we're trying to figure out if it's harmless?
I would think so. I think the question.
In other words, what I hear, implicit in your argument to this court is this is taken out of context. You've got to look at the whole thing. You have to see
Right.
that. I mean, if you put the words, "What do I have to do?" Threaten him with a baseball bat before he performs on time might be a different interpretation. But do you have case law that says we view it in the light most favorable to you?
I didn't address that issue directly. I think the problem is the instruction wasn't given. So the jury was deadlocked on whether he intentionally interfered for a while. The instruction should have been given. I don't see how you can say when the jury doesn't apply the right standard that there's no difference between the standards. There clearly is a difference. I mean, the judge instructed improper means would include a threat to kill, no matter how delivered, in what context or whatever, and therefore the jury just was not given the tools to judge it by the standard that applied. I think that's automatically harmful. I mean, I don't think you can go back and look at the evidence and say it shouldn't have been a jury question. I think that that it's fairly clear that this instruction is the one that applies to these circumstances. And clearly there's a difference between being instructed, did you use improper means by contemporary mores, but did you act with a spiteful, malignant purpose unrelated to any corporate interest? The latter standard clearly at least lets me argue and that Mr. Cashman was speaking in hyperbole and argue even further that that was made more clear by his apology if it was misinterpreted.
Well, I will ask Mr. Lorden
Multiple apologies.
I will ask Mr. Lorden the same question, which was on assuming, how can one simply, as it were, say, I don't have to reach the question, in a civil case, I don't have to reach the question because it was harmless. It was just harmless. I don't, what's the standard under which I'm reviewing whether it was, quote, harmless?
Well, if you're making the harmless decision, that seems to be a fact decision that the appeals court's making. We're looking at the evidence this way. You've deprived the jury of the right to look at it the other way. I think the appeals court said he's not entitled to the actual malice instruction because you can't threaten to kill someone however it's spoken, if those words come out some way or in some manner, that you can't do that because it's not related to, his potentially privileged comment. But I think that the harm is not in what the evidence is. The harm is the difference between a judgment based upon contemporary mores or standards and a judgment based upon whether there's proof of a spiteful, malignant purpose.
Have all efforts to settle this case been exhausted? The jury verdict was $27,000, correct?
That's correct.
That's not before us. Any issue of damages is not before us.
That's correct.
I guess you're here because you can't settle it.
That's correct. There have been efforts subsequent to the verdict, but not.
Costing both sides a fortune, in so many words.
That's correct. Usually I'm in the other shoes, so
picture.
I know. But it still, was a case that was not presented on the correct issue, which at least was actual malice. And therefore, Mr. Cashman's at a loss because he said, I really didn't mean to do anything wrong. Yeah, I spoke to Ferrari this way, but there's no way I meant to, threaten directly Mr. Blackstone or even had in mind his termination. What Mr. Cashman's testimony was, he was actually mad at Mr. Ferrari, not Mr. Blackstone, because he had asked Ferrari to police Blackstone in how he gave out the checks and treating the brothers equally because Blackstone had admitted I'm biased. I think
that's all evidence that would support no actual malice. So
that's correct, but they didn't know that standard. They had a different one, and certainly one that would make the law be, if you make an outburst, you're going to be liable if the employee chooses to lose.
Thank you,
leave.
Mr. Deptula.
Thank you.
Mr. Lawton?
May it please the Court, I'm George Lorden, and along with Attorney Dennis Derrick, we represent the appellee,
This is an
Tom.
awful lot of legal fees for $27,000 on a case that hasn't seen the light of print yet, because the appeals court memo is unpublished. But people want to do it, I guess, right?
Well, we're here.
And I know it, you're here,
Your Honor,
but you've got 130 days before the result comes out. Anyway.
my client was given a choice, your job or your life. And he took his life, obviously, as anybody would. Judge
Mr. Lawton, could I just ask you, could you, just assume with me for the moment that the instruction should have been given. I'm not asking you to concede that, just assume it. What was the basis, I mean, how is the appeals court undertaking its harmless analysis? Do we look at it in the light most favorable to Mr. Cashman? Do we simply say, look, this is a civil case, the instruction wasn't given, the jury, whatever you may view of the evidence, Mr. Deptula wasn't, if he was the trial counsel, was not permitted to argue to the jury this actual malice, which may have been compounded by the instruction on improper means, because I think we could all concede that threatening somebody's life is an improper means. So essentially what, as I understand, stripped of all of its essence, if you misinstruct the jury, assuming it was misinstructed, and you've given them not only haven't given them instruction, but that you've given them an instruction that in the context of this case is peculiarly misleading, how can we simply say it was harmless? Because we would all know that this wasn't a good thing to do?
The failure to give the malice instruction, I don't think was error, and I'll tell you why.
Okay.
The malice instruction comes up in the context of an employer and an employee. And the employer should be able to act for the corporation without worrying about personal liability, assuming that he or she is pursuing a legitimate corporate purpose or a management prerogative, as Justice Cowan said. In this case, Mr. Cashman, the defendant, was not the employer of Mr. Blackstone. They had made an agreement in the wind down of the company that all employment decisions rested with the CEO, Mr. Ferrari, hiring, firing, promoting, salary increases, and so forth. Mr. Cashman was a director and he was a shareholder.
50% shareholder.
And a closely held corporation.
That's true. However,
and viewed one way, the agreement was in essence was to deal with the conflict between the two shareholders. It had nothing, from the employee's point of view, it was the corporation that was the employer.
the employer in the first instance, Mr. Blackstone, reported to Ferrari. He did not report to Mr. Cashman.
Right.
There's no evidence in the record from the trial under which Mr. Deptula can argue management prerogative. There was no evidence that Jamie Cashman was the employer of Blackstone. There was no evidence of a legitimate corporate purpose that Jamie was supposedly carrying out when he made these threats.
Well, if he had been complaining that Mr. Blackstone had been unfairly withholding checks that were rightly due him, requiring him to indemnify Mr. Blackstone, which I don't know where that comes from, and very angry about how he was dealing with corporate business, because the payment of checks to major shareholders is certainly part of corporate business. Are you saying that that conversation is not covered by the privilege, regardless of whether there was, threats to kill? Even if there was nasty stuff, he's acting like a complete bastard or whatever it is, you're saying there's no privilege protecting that in these circumstances?
Absolutely. If you threaten to kill somebody and then they apologize, that doesn't,
No, I'm saying,
Keep
but
the threat to kill.
leave the threat to kill out. Very angry language about Mr. Blackstone's performance by a director and 50% stockholder in the corporation to the person who's nominally in charge of employing and supervising this person. Are you saying that conversation is not protected by the privilege?
I am.
Okay.
You have
And
to
what's your authority for that?
Well, you have to look at the context, Your Honor. Not only had Jamie been complaining that supposedly Blackstone was siding with his brother, Jamie had sued my client previously. The corporation evidently, through Mr. Ferrari, agreed that this was not just an idle thought that was soon retracted or an idle threat that was soon retracted. The corporation paid Blackstone $100,000 not to sue them. So they evidently believed that there was more to this than what Mr. Deptula would have you think now, that it was just an idle comment and an apology covers it.
But isn't that the question for the jury to decide, whether there's actual malice here? I mean, you're building a case that there was actual malice. Well, that's fine. The jury wasn't charged on the question of actual malice.
I don't think the jury had to be charged. I agree with Judge Kane. Until there was evidence that Jamie was his employer, there are no management prerogatives. The evidence in the case is...
Mr. Lorden, if I can just interrupt you. The first question to the jury was, did Thomas Blackstone and the Cashman company expect continuation of Mr. Blackstone's employment with the Cashman company? So the employer here is Cashman company. It's the corporate employer. Now, correct?
I would say the employer here is the CEO on behalf
You
of...
can't do that. Not when the jury question says it's a Cashman company. Mr. Ferrari, is it Ferrari?
Ferrari, I believe it is.
Well, I just wondered if, it's such a gorgeous car.
Well,
but anyway.
he was the one who would be offering continued employment on a full or a part-time
Right, but
basis.
the employer is still the company. Mr. Ferrari wasn't paying workers' compensation insurance and unemployment insurance and...
Yeah, I think you're barking up the wrong tree on that one. Might this not be harmless in this sense? Mr. Cashman, let's assume, could represent and did represent the corporation. He owns half the stock. However, putting aside the question of malice, there simply cannot be a privilege for someone in his position to threaten to murder somebody else. Correct?
Correct.
Now, despite the fact our cases appear to have schmushed this notion of privilege and malice and put them together in so many words, they all dealt with cases where there was some contextual evidence that fell far short of what was said here. So looked at in that light, the judge's instruction was probably correct.
Mr. Cashman was a passive investor. He had contracted
Going
away...
back to the other thing, I'm just asking you whether, there can be no privilege to threaten murder.
Well, I agree. As a general proposition, yes, and certainly within the...
General, as a specific, and as a whatever other kind of way you want to call it.
How can it be privileged?
Mr. Lorden, let me ask you this, if I can.
This is not the mafia.
I'm looking at the appeals court decision, okay? And it starts off essentially along Justice Glaney's lines. How can you, have this privilege to threaten to murder somewhere? What it says was, this case was not about Cashman seeking Blackman's discharge, complaining about Blackstone's job performance, or his alleged bias, or taking other adverse employment action against him. Now, Mr. Deptula has stood here to say, and you essentially heard Justice Cordy saying it, look, conceded this statement shouldn't have been made, but in fact, he had been complaining about Blackstone's performance. That's what he was upset about. This wasn't the first time this happened, and it had got to the point that he called up Ferrari and blew off steam. So, do I go along with the appeals court on that, or is there no evidence in the record of this prior dissatisfaction with Mr. Blackstone's performance?
Assuming for a minute that there's a privilege, that there's some management prerogative that attaches to Jamie, and there's a legitimate corporate purpose, wasn't the appeals court saying it wasn't about his performance, it was about the hostility between the two of them, and that is not a legitimate corporate purpose, and therefore he wouldn't come within the terms of any management prerogative privilege? And also,
If the hostility was wholly unrelated to corporate business, I might be willing to concede. In other words, they have been sparring neighbors. But here it seemed to me that the source of the hostility was this financial officer is not doing what he is supposed to do with respect to a 50% shareholder. The checks aren't there on time, whatever the claims were. I mean, it's not that the hostility was unrelated to the activities of the corporation.
well, it's disputed whether or not Blackstone was performing his duties adequately. Jamie didn't think he was, but that was his opinion. But certainly, by any measure, threatening to kill somebody is malice. And I think the appeals court was saying that he can't, there's no evidence of a legitimate corporate purpose when Jamie says to Blackstone, I'm going to beat you with a baseball bat. That's not a corporate purpose. That's not in aid of getting his check on time and so forth.
What if he said, if you don't do anything about this, I'm going to come down there with a gun and put it to his head and make sure he does his job right? I mean, that would certainly be a hyperbolic statement, and it's certainly illegal to threaten someone with the gun, but what about that?
Well, it was stated earlier, you have to put it in context. As I mentioned, the company paid $100,000 to get a release, and maybe the corporate attorney should have gotten a release for the owners. But Jamie had a history of an ungovernable hot temper, and he had brought a lawsuit against my client previously. So this wasn't an isolated thing said in the heat of the moment. He'd been fussing about Blackstone being an employee for years.
But doesn't
Doesn't
that go...
Oh, I'm
Go
sorry.
ahead, excuse me, Judge.
Doesn't that support the argument that he was just blowing off steam? He was just venting as opposed to making a death threat?
Well, he made believers out of the corporation. They didn't give away $100,000 because they didn't believe him, because they thought it was a momentary fit of pique. They obviously believed that there was some threat to the corporation, that this was way beyond any kind of acceptable civilized behavior.
Well, surely it was, and that's surely evidence of actual malice. But the question here is that the jury was never instructed on actual malice, and our responsibility in this case, in part, is to determine whether they should have been. It may well be that it wouldn't have made a difference to the jury because these statements were so far over the line.
I agree. I think if you did find there was a privilege, what he did was so far beyond that nobody could possibly justify it. But Jamie wasn't the corporation. The corporation was the employer. And you have to look at the cases that say management prerogative comes up with the employer and the employee. Now, to be sure, he's a 50% owner and so forth. He had no role in the day-to-day operations, none. And there was no evidence in the trial, and there has to be evidence in the trial if you're going to argue this theory. There was no evidence in the trial of what the corporate purpose was for which Jamie was threatening Blackstone.
Well, then explain it to me. At least as I read the briefs, he was threatening him in connection with Blackstone's failure to forward him checks that were required to be forwarded to him.
I agree, and you see that as a corporate purpose, but I do not. How is it the corporate purpose for the employee to
Excuse me. A CFO is required, in this case, to send checks to shareholders who constitute 50% of the corporation. It's not a corporate purpose. If he doesn't do his job right, that's irrelevant in some fashion
If he
to the corporation?
doesn't do his job right, that certainly is not irrelevant to the corporation, but pecuniary gain by one of the owners of the company is not a corporate purpose.
No, but surely there is a privilege of a owner, part owner, you're a 50% owner, to complain if employees of the corporation are not doing their job or not doing it properly.
Well, I would agree with that, but, this goes so far beyond a civilized complaint that it's just the law of the jungle with this fellow. You either do what I want or I'm going to kill you. Certainly that can't be privileged.
Thank you, Mr. Law.
Thank you.